Howdy, everyone. Welcome to Interacting with Government Agents and Other Officials. I'm David Glaser, and we'll dive into the substance in just a second, just our handful of announcements. So next month, we've got a Don't Want to Miss It webinar. Pari Megara and I, but mostly Pari, are going to talk about the Medicare manuals and how significant they are. So you find a problem where you violated some text in the Medicare manuals. Do you need to refund? There were two Supreme Court cases last month that offer some insight into that question. And Pari, who's an administrative law expert, is going to help us walk through the role of the manuals. We have joined Twitter. So if you look on Twitter for Fred Health Law, the coolest thing about this is Briar Andreessen, my colleague, runs the Twitter page, and she's the funniest person I know. So you can follow us there. Our old webinars are available. This one will be available. You can look, if you Google Fred Law webinars, it'll take you right there. You can look at all of our old webinars. We've been doing this for about 13 years. I think we've got about, I don't know, probably 9 years of them available online. So you can stream them, send them to friends, or whatever. All right, so many of you guys know that I love storm chasing. And if you look at the car in the lower right here, it's a little too close to that cloud on the ground. There's a tornado on the ground there. The little hanging things to the left also became tornadoes. This was a chase I did in Mayville, Missouri. And life is often like this, right? You don't know how bad the things around you are, and you're trying to figure it out. And when it comes to kind of government investigations and people wanting your medical records, there's some similarity to this. So here's a framework that I think is a useful one to consider as you analyze any refund question. It's sort of the three questions you want to ask yourself. Can you release this information? Do you have to release the information? And should you release the information? And what's tough about this is there are going to be kind of sometimes where you've got a patient consent or something like that. Sometimes you must. Maybe the government has a subpoena, or we're going to talk about the immediate access provision. And there are times where you should, where maybe you'll be helping people. And I guess as part of the can, you have to remember there are times where you can't. So maybe if it's a drug or alcohol record, those have a heightened level of protection. And there might be situations where you are unable, it's completely illegal to disclose the information. As you wrestle with this problem, you're also going to have to know, can you release it to whoever is seeking it? I'm a big Gary Larson fan. This cartoon captures it really well. Now wait just a minute. How are we supposed to know that you're the real angel of death? Now, I've never asked the angel of death for ID. I think usually you're distracted when he or she is around. But with government agents or someone who's asking for medical records, this is the big question you're going to want to ask. In fact, I've captured it on this slide. And as you look at this slide, there's a theme here. And there's a prize available for the first person who identifies that theme. So you want to ask, who are you? And I think we already have a winner. And indeed, the theme is, these are all Who songs. So who are you? Perhaps one of, it's a repetitive but favorite Who song. You better get ID from whoever the person says, because you want to figure out if they are the real me so that you are not fooled again. Now, the slide says, don't say I can't explain. That, I'm limited by my Who songs here, because the Who don't have a song that says I can explain. And I don't really want you to say I can't explain either. Really, initially, you're trying to figure out what the principle is. And here's how I handle interactions with government agents when they show up. I think you say to them, hey, I might be able to give this to you. I might not be able to give this to you. Put the patient first. I need to figure out if I have the right to give it to you or if I don't have the right to give it to you. And so I'm going to figure that out now. Give me some time. So basically, you want to relax. And that relax leads me into a segue of a few stories I want to tell. So I had been a lawyer for, I believe, 3 days when Jim Platt gave me my first interaction with the government. One of our clients, a clinic, had received a subpoena from the postal inspector. So then they did the first thing you don't want to do when you get a subpoena, which is they put it in the too hard pile. They put it off to the side and they just completely missed the response date on the subpoena. So they then got an angry phone call from the postal inspector. And I was calling them to explain that, in fact, merely the subpoena was insufficient and that under Minnesota law, we were going to need a court order. And the postal inspector got quite angry with me and asked me if I liked my freedom and insisted that if I wanted to spend the weekend in jail, I was on the right path, but that if I wanted to remain free, they were going to have to produce the records. And I had to explain to this agent that while in some states at that time, this was actually pre-HIPAA, a subpoena was sufficient to get records. In Minnesota, it was not. So after he yelled at me for a little while, we actually reached some sort of resolution. He understood it and he went off and he got his court order. But one of the challenges as you're interacting with a person with a gun is to stay calm. And so the relax part of this slide is really important. Next story, fast forward just a little bit of time, was a couple of years when the Nuclear Regulatory Commission showed up at one of our clients. I had never encountered the Nuclear Regulatory Commission. I had no idea what their authority was, what they were entitled to, and had to figure it out. So why am I telling you these two stories about my ignorance? Am I trying to demonstrate that I am an incompetent lawyer? Well, that is not actually the goal of these webinars, and hopefully it's not even true. But I'm telling you because even us lawyers are going to run into situations where we're not clear what the answer is. And it's okay to embrace that uncertainty. In fact, if you think about what its confidence is, some people would assert that confidence is knowing the right answer. And I would assert confidence is something very different. Confidence is being comfortable with the uncertainty of not knowing the right answer. And when interacting with the government or anyone else who's looking for records, cool confidence is the way to go. And that doesn't mean having certainty. It means being willing to take the time to figure out what the right answer is. All right, here are the agencies that can darken our door. And first, I have to disclaim the shark that is on this slide. Our daughter is a big fan of sharks, and whenever she sees me give this speech, she gets mad at me for having a shark as a sign of trouble. And so I want to be clear, sharks are not trouble. Some of you may have seen the video last week. A dad was filming his kids in the ocean and using a drone. And this shark was swimming really close to the kids. And this video made a lot of news. I think with the boy, look at how much trouble the kids were in. Of course, nothing happened to the kids. And it does make me wonder how often sharks are in fact swimming really close to our kids and there's no drone nearby and we don't know. It's a good lesson about news generally, right? You only hear about kind of the weird thing in there, but I digress. So CMS, you know, the Center for Medicare and Medicaid Services, we don't know what happened to the M. The OIG, the Office of Inspector General, and the Medicare Police. You all know the FBI, and as an aside, I think it's the Killers of the Flower Moon. I always get the title wrong. The Flowers of the Killer Moon. It's got moon, it's got flowers. It's the story about the birth of the FBI. I'm just finishing it right now. A very interesting book. The Medicaid Fraud Control Unit, which is pronounced Mafuku, which sounds obscene, may show up doing a Medicaid investigation. Then the next three are most likely helping out Medicare: the Postal Inspector, the Inspector General of the Railroad Retirement Board, and the Defense Criminal Investigative Service. All of those government agencies will occasionally help because there aren't that many government agents out there. In fact, the OIG has been laying people off left and right. So there are states right now that don't have an OIG agent. And so sometimes the investigation for Medicare might be run by a postal inspector or someone from the Defense Department. Licensing boards are a little bit different than some of the other agencies, in that they have the ability to compel you to speak. And so if you're a licensed professional and someone from your board shows up, you might have to give them information, but you don't have to do it that very second. The State Department of Human Services and Department of Health can come by and often compel things. I don't have as much FDA experience, but they certainly can show up looking for things. The Drug Enforcement Agency can be looking either at its registered professionals who are prescribing. That's kind of the most likely way they're going to show up. ICE is a big issue for a lot of people right now, immigration. And it's important to realize ICE doesn't have any special power. So they're just like any other government agency. We'll have some slides about them shortly. I've mentioned the Nuclear Regulatory Commission. One of my colleagues has become a bit of a National Transportation Safety Board expert, unfortunately, because she's had to deal with helicopter crashes and the like. And so they could show up. Plaintiffs, it's usually the plaintiff's lawyer who shows up. They don't have any special authority. And reporters. And a theme that you hear throughout this is make sure you verify someone is who they say they are. If a reporter calls you, they're probably truly a reporter. But if you get their information and take the time to call them back, it gives you time to collect your thoughts. And we'll kind of come back to that in a bit. So here are the relevant laws. Now, most of you know HIPAA, right? But here's something people often forget. HIPAA sets a floor and not a ceiling. So HIPAA is a national law. Often when you have a national law, it will preempt state laws. In other words, it takes control and the state law becomes irrelevant. With HIPAA, that is not true. Under HIPAA, state law can give more protection to a patient than the federal law does. And many states have higher protection for medical records than the federal law. So if you're listening to a national seminar on HIPAA, or you go to a speech, and they say, under HIPAA, you can release X, you can't assume that that's true for your state. And that's a challenge. We've got people on from all 50 states here, so it makes it difficult. So for example, Minnesota, more protective, but that's not helpful for the people who are listening right now from Hawaii. So you need to know your state medical record statute. Now, almost every state is going to compel reports in certain circumstances. Vulnerable adults or child abuse and neglect, almost always going to have to report. If you've got a duty to warn, so you've got a patient who's threatening someone, most states will require you to report. You'll have a duty often if the Department of Health shows up to do a validation survey to report. And then, of course, there's Medicare's immediate access provision. So let's talk about that for a moment. So some dude shows up and says, I need this record today. So I'm going to beat the dead horse, ask for ID, make sure you know who the person is. I've had at least 3 occasions where a person purported to be a government agent and was not. You call the number on their business card and you get doo-doo-doo. The number has been disconnected. Here's a principle that I think applies not just in the context of medical records, but when someone is telling you that you need to do something. The more they yell, the less you should trust them. People who have authority for their position just give you that authority. If someone's yelling, it's quite likely that they're bluffing. The Teddy Roosevelt principle of speak softly and carry a big stick applies when someone's trying to make you do something. So if someone comes in and tells you that this is the law, ask them to show you the law. If they're right, this is not a difficult question for them to confront. And if they give you all kinds of reasons why you're asking this question is obnoxious, then the law probably isn't on their side. So what about this immediate access provision? We'll have that on the next slide, but make them show you the rule. And the immediate access provision is a great example of why show you the rule is such an important way to take things. So here's the Medicare statute. So the secretary has the ability to exclude anyone if that individual or organization fails to grant immediate access upon a reasonable request to, and then it gives you a list of people and situations. So if you fail to give the Inspector General the ability to review records, to do any of the Inspector General's sorts of duties, you can be excluded under this immediate access provision. So this raises the obvious question of what is immediate access? And under common sense, you might think like that very second, right? That's how I would assume immediate access is defined. But if you look at the bold underlined, it refers to a definition by the Secretary and regulations. So let's go to those regulations. Well, immediate access is defined as within 24 hours of a request. Not what I would have assumed, right? And actually, it's either providing the records or a compelling reason why they can't be produced. And if it's a list of 500 records, that might be a compelling reason why you can't do it within 24 hours. So it's not like you have 10 seconds to get them with the records. And there's certainly time for you to take a deep breath and figure out, A, are they entitled to the records? And B, make a copy of them so that you're providing a copy, and make a copy for yourself so you know everything that went. But the key part here is that you need to see the rule, because if you didn't look at this definition of immediate access, you'd come to the wrong conclusion. All right, so let's look at first contact. You know, you might get a personalized letter. Those are rare. Overpayment letters, you usually have time to talk with counsel about those. You know, you might learn something from Medicare bulletins or denials. And then there's the routine audit or a survey. And there's nothing routine about an audit. It's routine for the agent. And this is another thing to keep in mind. They are calm and think something isn't a big deal because their whole life is going in and investigating people. What's routine for them ain't routine for you. Now I want to tell the story of a nurse who was at the University of Utah, and I would call her a hero of mine, because facing a really belligerent police officer, she stood her ground. And it's a long video, I think it's a half an hour. The Washington Post did this story. And if you Google Washington Post, Alex Wooble's University of Utah, it'll pop up. It's like a half hour. I don't know that you want to watch the whole thing. It's painful to watch. But she did a remarkable job of staying calm. You got to give kudos to the University of Utah. They had policies in place, and she knew where to find them. She looked stuff up and knew what was going on. I've talked about the inability to unring the bell. And so the question is, are you going to do permanent harm if you wait to find out whether you can release this information? And the answer to that question is almost always no. We'll talk about a couple of the exceptions coming up. But can you take 15 minutes to figure out whether this information should get released? There really aren't going to be very many situations where the answer is no, you can't wait 15 minutes. And she was trying to get the officers to understand that, and the officers were being extremely confrontational. So if you listen to the tape, one of the things the cops said is, well, why don't we just write a search warrant? One officer says to the other. And the second officer says, we don't have probable cause. He just said PC, but we know what that means, probable cause. In other words, translating that into slightly more direct language, we don't have the authority to get this we don't have enough to get a search warrant. So under the law, we can't get what we want, so we're just going to bully this person into giving it to us, all right? That's the code words that are being articulated here. Now, there are two recent Supreme Court cases, and I would not claim to be an expert on either. The most recent, which was just last month, is Mitchell versus Wisconsin. I think it was 2 years ago, maybe 3, Birchfield versus North Dakota. Both involve patients with a DWI. In Birchfield, the patient was conscious. I think I've got this, I won't confuse these two. The patient was conscious, and the Supreme Court concluded that you need a warrant to take blood over the objection of the conscious patient. In Mitchell, the patient was unconscious, and the Supreme Court concluded that that you didn't need, that it was implied consent and that a warrant wasn't necessary to take the blood. But this is a really super duper important point, and not one I would have found obvious. And I give credit here to Pari Magera, my colleague, for helping to teach me this. The fact that the government may have the right to take information because of the presence of a search warrant doesn't mean that you, as a medical professional, have the ability to act as a surrogate for the government. That is very much an open question. And so if a police officer comes in and hands you a search warrant and says, we need to get this stuff, it is not automatically clear that you, the healthcare facility, can become an agent for the police and execute the search warrant for them. And in fact, there are questions as to whether that screws up the validity of the warrant. So this is a tough question. I don't really expect to answer it definitively on this webinar, but don't feel like you need to do something because a police officer shows up with a warrant. Actually, I'm jumping ahead a couple slides, but the officer said, I've never gone this far, which is an interesting tell. And I think part of why the officer has never gone that far is he hasn't run into as many people who have as much courage as this nurse did. This line always makes me think of the Reeses peanut butter cup commercials, which is your policy is interfering with my law, which for some reason makes me think of your chocolate is in my peanut butter. But both of these statements, so your policy right now is contravening what I need, and your policy is interfering with my law. Now, those two statements are really different. Your policy right now is contravening what I need. The fact that the police officer needs something doesn't give them the right to it. Now, when they say that it's interfering with their law, if true, that would be material. It just wasn't true there. There was no legal right to get the information. But listen closely to how the officer frames their ability to get it. So the fact that it's getting in the way of what they want or need does not matter. And if they tell you it's interfering with the law, ask them what law and ask them to explain where it's coming from. So, could the nurse have videoed the encounter? And the answer to this is an unqualified yes. You can videotape encounters with the police. It often irritates the socks off of them. My colleague Kevin Rich defended a man who was accused of interfering with an ambulance crew because he was standing on his porch filming the ambulance crew that was working in the street. Kevin was successful in his defense because it turns out sitting on your porch isn't interfering with anybody. And running a video camera is not interfering with anybody. So it is legal to record, period. At least 17 states, and maybe more by now, have an app from the ACLU that's called Mobile Justice. And I highly recommend you get this app. If you're out on the street and you see something going on that you want to videotape, this app allows you to do that, and then it uploads automatically because sometimes officers have the bad habit of trying to confiscate people's phones when they video an encounter. And occasionally videos have been known to just disappear. So a way to fight that is this app, which uploads it immediately so the video can't disappear. Contact your general counsel. If you have internal general counsel, great. If you don't, call us, call your law firm or whatever. Get on the horn immediately. And this is why it's helpful to have multiple people in the organization who understand what to do, because this nurse was arguing with the police officer. She's going to rely on a colleague to call the general counsel, right? She's busy. They at some point handcuffed her. So someone else is going to be responsible for intervening and calling for help. And so if you're in a situation and you see something like that going on, please do that intervention. So the basic principles of the interaction. Friendly is always the way to go. And the nurse was really good at this. Think about different ways that you can say no, right? So you could, if the officer asks for information, you could say no. That's somewhat antagonistic. You could just, I won't give it to you. But what if you frame the same thing using sort of the original slide we talked about here? Hey, look, patient confidentiality is a big deal. And I know there are times we have to give you information, but I also know there are times we can't give information. And I just need to figure out whether this is one of those times where we have to give it to you or one of those times where we can't give it to you. So if you could just be patient while I work with legal to make sure, because obviously, this is all about the patient. And police officers are often going to be either saying or thinking that you're covering something up for someone. And if you can reframe it so that we're talking about patient protection, it tends to de-escalate everything. So if they don't have a search warrant, you have time to figure out what's going on. And then this is the point I was making about before. The search warrant lets them get documents, but it is not obvious that a search warrant can make you do anything for the cops. In fact, I think I would go so far as to say it can't. It just isn't perfectly clear on that one. So the fact that they're waving a search warrant around doesn't make you search a person's body cavities, all right? They can, but that doesn't mean you can. And then be cynical. Question what I'm saying to you, question what they're saying to you. So now, most of the rest of this is going to be examples, and then at the end we're going to do what do you do when the cops show up. So a patient says, I take illegal drugs, so can you turn them in? Well, this one's a little complicated. I think you have to ask yourself, why are they telling you? If they're telling you as part of their treatment, that probably makes it confidential. It's helpful to think of the policy. The reason we have confidentiality of medical information is so that people will feel comfortable talking with their medical professionals. And so as a general principle, information that's disclosed as part of a patient trying to get treated is going to get a higher level of protection. By contrast, if they're sitting in the waiting room and you're the receptionist and they're like, hey man, how are you? How was your weekend? Well, I just took some illegal drugs. That'll be less likely to be protected because it wasn't part of a medical conversation. It was just a conversation. Now, does that mean every time a patient tells you about taking illegal drugs, you can't tell anyone? And the answer is no. And that's because a lot of the time what we have going on here are balancing tests. And so if that patient who's taking drugs is pregnant, that might trigger reporting under your state abuse and neglect reporting. If even they're a parent and you think that that taking of drugs makes them an unfit parent, that might trigger a duty to report abuse and neglect. But once again, there's not a giant rush. You get time to think about it. And I guess the long and short of it is, before disclosing information to a government official, I would make sure you're running that past your legal team. A patient shows up and they've overdosed, and you find drugs in their pocket. What do you do with them? Well, I think the general approach to this is you flush them down the toilet. Now, I worry a little bit about this with, is someone going to accuse you of obstructing justice? But in the balancing test of what's going on, there aren't a lot of great options here, right? I don't love the idea of saying to the police, hi, we've got these drugs from this person. I certainly don't want to keep them around, right? The keeping them around seems like the worst idea because it's a safety issue and then you're in possession and all that stuff. So your choices really seem to be turn them over to the cops or dispose of them. And the facilities we work with generally fall into the dispose of them department. I'm kind of curious if you're out there and you take a different tact, I'm kind of curious about it. You can shoot a thing to Dan. All right. I don't have to make most of these examples up. This is one of the weirder ones I had. I was a baby lawyer. In fact, my colleague Shelley Boynton and I were working on this one when a patient called up and said, my husband is poisoning me with cow hormones. I think, if memory serves, she was, I'm trying to remember if it was she was pregnant or maybe wanted to be pregnant. I think she wanted to be pregnant, and the husband was supposedly giving her these so she would not become pregnant, according to her. And we had to decide, were we going to report this to the police? And the ultimate question we had to ask was this person who was in the hospital at the time a vulnerable adult? And you could make an argument on either side of this, right? The best argument she was vulnerable was, well, first, by definition in Minnesota, if you're in the hospital, you're a vulnerable adult. But on the other hand, she had told us what was going on. She seemed capable of reporting it. It was a hard question. We ultimately had the care team talk with her a little bit more to try to figure out what was going on. And they actually came to the conclusion that she probably wasn't being poisoned. She was having a psychotic break of some sort, and they wound up treating that. Patient steals a wallet. So this is an easy one. You can turn in patients for committing crimes in your organization. It's not related to the healthcare. If someone comes in with a gun and they're shooting at people, you don't have to worry about privileges. That act isn't related to healthcare, and you can call the cops. Next, I want to talk about the OK penile bite case. Now, there are a bunch of ways you could misread this thing. When I say OK, that is not like acceptable, but Oklahoma. And if you're thinking about what is a penile bite, it is not like a male genital that's going crazy out there. It's a tragic situation. It's a sexual assault victim bit her attacker. And so the police called up and said, we're looking for a patient who's got a groin bite. Do you have anyone there who meets these criteria? And the nurse in the emergency room said, as a matter of fact, we just treated a patient for a penile bite. And then in the Chutzpah 101, that patient sued the hospital. So what do you think happened? So first, can someone sue? Can that person sue? Of course, someone can always sue. So how did that lawsuit fare? Well, not too surprisingly, the person lost. Now, how does this balance with what I've talked about? Should the hospital have given that information up? There's an argument that they shouldn't. And this is where the balancing test becomes a big deal, because maybe they shouldn't, but the patient didn't win their lawsuit. And the patient didn't win their lawsuit because I think everyone goes, in this particular instance. And I think, to me, a material fact is the patient had left. And so I'll contrast this with another situation we dealt with, which was a well-known person murdered his ex-wife and her boyfriend, and then went and checked in at a psych unit. And the police called, or the question is, can we tell the police that this person was in the psych unit? And the answer we came to there was no, but I would have reached a different conclusion if we were about to discharge the patient, because I think then there's a threat to others. So this is a close call. It is not crystal clear to me that the hospital was permitted to release this information, but they didn't get in trouble for it, and you can understand why. So know your injuries. Most states have laws that require reporting of certain injuries or diseases, and one of the challenging things of having people from, I don't know, I think we might have literally every 50 each of the state represented today. There's no realistic way to go through this, right? But most states require you to report gunshot wounds or stab wounds or burns. And so you kind of have to know what your state law is, because if someone shows up, and that's sort of, the fact that the person had been bitten wasn't as clearly reportable as if they had been shot. Sometimes that reporting is aggregate and you don't give patient-specific data. Sometimes you have to give the patient's name. And I apologize, we can't be more useful here. One of my first memos as a young lawyer here was writing like a 30-page memo on every Minnesota law that required or permitted release, and it was hard. Okay, patient comes in and they use a fake insurance card. So, can you report them? Must you report them? Well, first, do you have a general duty to report illegal conduct? And the answer to that question is no. If you are watching someone rob a bank, you do not have a legal obligation to call 911. Now, some of you astute readers of the news might be thinking about the police officer in Parkland, Florida, who is facing charges right now for failing to run into the school in Parkland during the shooting. And you may think, wait, that person is being charged for their dereliction of duty. Is that not a duty to act? Well, I would say two things about that. One, I don't know that that prosecution is going to succeed. And second, the theory there is that the police officer has a duty to the chargees. And so chargees is probably a bad word to use there, because he's going to get charged for his failure. He got charged for failure to honor that duty. And you don't, for better or for worse, have a duty to your fellow people to get involved. Now, there's questions about whether the Kitty Genovese case actually happened as reported. Good documentary about that, by the way. But in her memory, if you see a crime, let's do the if you see something, say something. So I encourage people to report crimes when they see them, but it is not a legal requirement. But this is more complicated. So why is it more complicated? If the patient brings in a fake insurance card and you take the number and you charge the insurance company, you've just become a co-conspirator in their fraud. And so if you think that the person doesn't actually have insurance and you take the insurance money, now we're on the hook. And so does that mean you have a duty to call the police on the fake insurance card? No, it means you have a duty not to bill the card if you think it's not real. right? So the other way is you can say to the patient, look, we're not going to be part of this. We're rejecting the opportunity to use this insurance card. And one of the benefits there is that, like, if you do call the police and you're wrong, that's not so good. So what I would generally do here is not call and just not use the card. But that's more risk management advice. The only legal thing is that you're not required to call. All right, a patient forges an opioid prescription. Now, this one's a little different from the insurance card because, at least unless you're the one filling the prescription, it doesn't involve you. I think there's a pretty strong argument that you can report. It is not clear that you have a legal duty to it. The one interesting question, and I would worry about this some, is sort of in the duty to warn category. It is not inconceivable to me that a patient's family members sue, if you become aware that a patient had an opioid problem and you sort of allow that to continue, it is not inconceivable that a patient's family member sues you for failing to prevent their overdose or abuse of the drug. All right, so earlier we had the dude showing up and demanding records. Now the dude's partner, a dudette, shows up and wants to take pictures of your braces. And when I say braces, I'm not talking about the things that ruined my jaw back in my high school days, but rather my prosthetics, orthotics, and durable medical equipment. So this is the story at the other end of the spectrum. This is the time when you send someone away and you get in trouble. So Katie and Ilton and I worked with a client that had someone show up wanting to take these pictures. The receptionist said, "This sounds really fishy." And they had received an email from the person saying they were coming. The email had typos in it. So they did not believe that the person was who they claimed to be, and they sent them away. That went really poorly. They wound up losing their DME number. Now, that person was supposed to have an ID from the National Supplier Clearinghouse and a letter that said, "Hi, I'm with the National Supplier Clearinghouse. I'm here to check your braces." They didn't. We appealed, and at the first level of appeal, the administrative law judges rejected the appeal, saying, yes, it's true that the agent should have had their ID, but it's also true that the people have a legal duty to let them in, and they should have done so. I am stunned at that result, and I am going to say with a 98% certainty that if we had appealed to the next level and gone up into district court, the district court would have had none of this, because it just sounds massively unfair. The problem is it was going to take a while, and the client ultimately decided that it just wasn't worth it, and so they didn't pursue that appeal. So what's the practical lesson here? I guess there are two. One is sometimes the system is really unfair, but second, make people show you the ID, and then if they don't, document that more clearly, because the client didn't do a perfect job of recording their requests and the failure to show ID. I think if they had done a better job of that, it might have helped. So this is the one exception to the idea. This, I'm usually saying not giving information is less risky than giving it. This is the counterpoint. But I think that this was avoidable if they had just been more insistent on, please show me your authority. All right, ICE shows up and they say, hey, when is X's next appointment? So first question, let's make it not ICE. Let's just make it a state patrol officer. Can the police come in and ask when someone is coming in? And the answer is they can ask, but you can't tell them. All right, so what makes ICE different? And the answer is nothing. Now, ICE does consider healthcare facilities sensitive locations. So in theory, they really shouldn't be showing up at a healthcare organization and doing this. But that sensitive location stuff is merely a policy. As they say on their website, enforcement actions can occur at sensitive locations in limited circumstances, but it will generally be avoided. So you can't forbid them from showing up very easily, but they shouldn't be there, and you don't have the right to give them the information. I think that the patient has the right to confidentiality on these. So you remember, HIPAA is going to protect their presence at the facility. So now, can you tell the patient that ICE asked about them? I think you probably can. Generally, you're going to be allowed to communicate about information that you receive from the government. Can you tell them to go out the back door? That one is more complicated. And there's a Massachusetts judge right now who's under indictment because she, when ICE showed up to get people out of her courtroom, she said to them, hey, go to the back door. So that affirmative act allows the government to try to argue you're obstructing justice. Now, how that one's going to play out, we don't know, but it's harder for me to say that you can help sneak them out and that is legally protected. That one's just less clear. A state surveyor shows up and says, show me your peer review. So this is an interesting one in that the CMS requires a hospital, not a clinic, but a hospital, to have a peer review process. And because of this requirement, they are allowed to get information demonstrating that you have a peer review process. Now, that doesn't seem like it automatically allows them to see peer review data. We've gone to court on this one, but this is a really big conundrum because it turns out there is, so first you have to know your state law. So, and every state's going to have different levels of protection. And one thing to note, I would argue that in many states, peer review isn't actually a privilege. I would use a different term. It's a protection. So, for example, in Minnesota, it is a misdemeanor to release peer review data. Now, a privilege can be waived. So you can choose not to exercise the privilege. I would argue that in states where where it's a crime to release the peer review stuff, it isn't a choice, and you don't have the option of releasing the data, and it's stronger protection than a privilege. But here's a problem. There is a Supreme Court case referred to as the Illinois Counsel case, and if you've never heard of this, have your ears perk up for a moment, because this can save you a bunch of expensive litigation that will be unsuccessful. So this case arose in Illinois, where the state came up with a new rule, and nursing homes thought that the state was going beyond the authority given by regulations. So they wanted to challenge the new rule. So they went into court seeking declaratory relief. And that case was thrown out on the theory that the nursing homes needed to exhaust their administrative remedies. And in essence, what the court said is, you need to wait for the state to cite you, and then you appeal the citation. You can't, in advance of the citation, ask a court to tell you whether or not the rule is valid. I find this case really, really troubling. Clarence Thomas wrote the dissent in this particular case, and I found myself agreeing with the dissent strongly. I was shocked at how much I agreed with the dissent in this case. So there is a question: if you refuse to give your peer review data to the state surveyors, and the surveyors go to cite you, can you go into court before you get the citation and try to have a court say, no, these surveyors don't get to ask for this? Or do you need to wait for them to cite you and then appeal the citation? And there's an argument that that latter is true, and that's really crummy. Now, the counter argument is that in Illinois Counsel, one of the things driving the court's thinking was that the nursing homes were unlikely to face an actual penalty. So if you could show that you were truly going to be harmed by the action of your state, perhaps the court would give you the declaratory relief you seek. But just something to keep in mind. Accreditation surveys. Now, these are generally not going to be by government officials, so it's a little off of our topic, and you're generally going to have to cooperate, but the details may vary, and a lot of this comes down to what state law says. And this is where just politely ask for more time. You know, if the Joint Commission is asking for something, you may need to consult with counsel and see if they're entitled to it or not. The good news is that you should have a few hours are certainly going to be okay. There's not going to be a 15-minute requirement to give something to the Joint Commission. Licensing boards. So licensing boards are a little different from some government agencies in that many of them impose a duty to cooperate. So you can't refuse an interview, but that doesn't mean that the interview has to be conducted in the first 15 minutes. You get time to get counsel, and so if you are licensed, you probably have to talk to them, but you can have someone sitting at your side. This is a little off topic, but I just want to mention the duty to report to the licensing boards. And in particular, this is a mistake we see a lot. You've got a medical professional. You think they're trouble. You're firing them. You don't want to ruin their life, so you choose not to report them to a board. Here is the dilemma that ensues. The person, fast forward a month and they're suing you for wrongful discharge. And you say, well, we discharged you because you were a terrible doctor or nurse practitioner, fill in the blank. And the person says, you thought I was terrible? Did you report me to the board? And you think, well, no, I didn't report you to the board. We were trying not to ruin your life. Well, the board has a legal duty. If you thought I was a threat, you had to report me. Poof, your good deed has just hung you out to dry, and your decision to not report has just made your discharge really ugly. So slightly off topic, but kind of important. So do you memorialize your interactions with the government? I am not a fan of tape recording them, with the exception of the nurse, the one situation we were talking about there. Then I might video in that case, but otherwise I wouldn't. You got to know your state law, because sometimes state law does forbid, like, recording telephone conversations. Generally, face-to-face, you're going to have more flexibility, but on the phone, some states require consent from both parties. Some only require consent from one. So you need to know what's going on before you record. Contemporaneous notes are always a good idea. Just do a memo to the file, right? If you're ever asking for advice from the government, and that's kind of another form of interaction, right? You sometimes need to figure out if something is okay. If you get advice, I would follow up with some sort of communication, either maybe an email, but I am more a fan of a certified letter, because the certified letter proves that the advice that you actually communicated it back. And so it's just, on such and such a date, I asked you this question, you said this. And now you've got a permanent record of that communication, because we've had situations where people are like, we asked the government and they can't prove it. In one case, we finally were able to prove it because another client of ours had an email on the same topic, but it took us about 3 years to find that, in a situation where we could have ended some litigation a lot quicker if our client could prove that they had asked for the advice. If you're communicating with agents or U.S. attorneys, your communication should come through counsel. There are a variety of reasons for that. One of them is anything you say is potentially an admission. Another is you want to have a good record there. So if you're communicating with government counsel, then you absolutely want to have your communication going through counsel. Outside counsel is sometimes better, because we can, to be blunt about it, play dumb, right? I mean, we don't have an expectation to know everything. And that middle person can be helpful in an investigation. Now, this is just a personal comment about whether being the roughest, toughest, rootinest, shootinest claim jumper outside counsel. And because you see some people who want to be jerks, and that proves that they're effective lawyers. And I couldn't disagree more. I think you often pay more money if you've got a lawyer who is trying to fight over every procedural thing. I recently had a really major investigation, and the client spent a lot of money on it, but they spent a lot less because the government was flexible in how we did our discovery. And that flexibility was caused in part by the fact that we developed a really good relationship with the government. They trusted we weren't going to get rid of anything. And we trusted that they wouldn't ask for stuff unreasonably. And we got to a point where, this was a multi-$100,000 investigation, but not a multi-million-dollar investigation, and it could have been. So don't be Yosemite Sam. All right, I couldn't decide which eagle picture to use, so I've got two of them. That sort of the serious-looking eagle that I saw on my way home one day, and this one I saw one day on a run. Maybe been the same eagle, I don't know. That one looks a little friendlier because of the moon. All right, so when the government is out there, and if you see an eagle on a letter, that's a big deal. So anytime you get a bird, that's not a football helmet in the upper left corner, that's a bird. Any letter from a bird is a big deal. This happens to be a survey from the OIG. You can see it's from the Office of Audit Services. And this came out at a time when sales guys were saying, if you buy this device, it does a bunch of blood tests. A bunch of our clients bought those machines, and the doctors didn't know much about these automated hemogram indices. This is old. This was when I was a baby lawyer. I think it was in 1995. So I had a dozen clients who got this survey and who sent it back. And there are several lessons from it. So first lesson. So let's look at the survey. Did you order a complete blood count? Yes. We're going to skip ahead to this one. So did the lab tell you that the automated hemogram indices were automatically used as part of the profile? Now, these were physician-owned clinics, and the doctors said no. So first question is, does the government going to believe you if you're the owner of a practice and you're billing for something and you assert that you didn't know you were billing for it? And I think the short answer is no, they're not going to believe you. Were you aware that these were billed to the Medicare program? Once again, the doctors said no, and once again, the government's not going to believe them. And here was the big question. Were the indices useful to you in the treatment of the Medicare patient? I worked with a dozen doctors, 11 of them checked no. They did not think that the indices were useful. Did those 11 doctors just admit submitting false claims in a form they were sending back to the Office of Inspector General? Potentially, yes. Now, I can come up with an argument that the answer is no, and my argument is, in hindsight, they weren't useful, but if you ordered them thinking they'd be useful, you could still be okay. The problem with that argument is that the doctors, when they ordered them, didn't even know what the automated indices were, and so no, I think they just admitted submitting false claims. As Gary Larson would say, open the gate, it's a big wiener dog. That wasn't a survey, that was a giant problem. And be careful when you're sending a form back to an insurance company or the government. The fact that it says it's a survey doesn't mean it can't be used against you. So how do you know you're in trouble? If you get a request for more than one record, you're in trouble. A request for one record is often not about you. I don't lie awake nights worrying about a request for one record. I don't think you need to call us every time you get a request for a record. If you get a request for multiple records, call your legal counsel. All right, so if you get an overpayment letter, that's also a big deal. And then, of course, if armed agents pop up at people's homes. And does this happen? Yes, I will bet that someone who's listening to this webinar will have agents show up at their employee's home sometime in the next year or two. I would take that bet. Will all of you? No. Will one of you? Yeah. So preparing for that is a big part of that. And you can prepare. One of the things you can do is have people watch this webinar, right? As part of your compliance training, let people know that what we're going to talk about in the next 10 minutes here. So, and almost anyone could get visited. It could be your receptionist. It could be your nurse. Anyone in the organization, IT might get the visit, right? It could be in a wide range of places. Whatever prep work you do, don't count on people remembering it. One of the more painful experiences of my career, I was working with a device company. They had an investigation. We did compliance training the last week of July. The first week in August, we're sitting with government investigators as they interview one of the company's employees. And they asked the employee, have you ever had compliance training? Now remember our time frame. They had the training 1 week earlier. And the person said no. So it's a little alarming. No matter what you do, people aren't always going to remember. But train people and then train them to know how to get a hold of people at weird hours. All right, I had an orthopedic surgeon who got a grand jury subpoena from the U.S. attorney in Atlanta. And it said, the United States attorney requests that you do not disclose the existence of this subpoena. Any such disclosure would impede the investigation and therefore interfere with the enforcement of the law. This makes it sound like that if you tell someone about the subpoena, you're obstructing justice and going to jail. I think it is unethical for the U.S. attorney to have put that on. My understanding is the government has stopped putting language like this in subpoenas because it makes it sound like you can't talk to legal counsel. And in fact, you can talk about communication with the government if it's not like with the exception of terrorism investigations and some banking investigations. There are federal laws that can allow the government to prevent you from talking about them, But if it isn't terrorism, it isn't banking fraud, if it's any health investigation, you can talk about the contact. If you get a letter, letters are the easiest thing to deal with because you have time. Figure out who sent it. Make sure you keep a copy of everything. We have clients who sometimes are like, well, it's an electronic record. We've always got it. You don't know what you sent back. You know, did the imaging go in? Did the electrocardiograms go in? Make sure you keep, if it's going electronically, keep a flash drive of it. If it's in paper, keep a complete paper copy. The other thing is if they lose it, you don't want to have to go pull it again. Just have a copy of what you sent so it's easy. And it's an easy thing to do, and it's a mistake people make a lot. When in doubt, I always send more. People worry about that they'll get investigated for the information they sent in, but I'd rather the person have a complete record than an incomplete record. If someone shows up on site, try to keep an eye on what they're looking at and make sure that they don't leave with anything. We had a client in New Mexico where Medicaid was there and they walked out with original patient records. That's not cool. Try to keep the auditor away from your staff so they can't ask questions, and then we're back to our friendly and firm. Okay, often you get surprised in life. This looks like I altered it because for whatever reason the picture blew up. I took this picture, I was out walking with my spouse and the dog, and this deer, you can see, jumped in front of the biker. I mean, it was 3 feet in front of the biker. This picture is a little bit better on the next leap here. Sometimes life surprises you, and when a cop shows up, it surprises you, right? It's scary. If you answer the phone and they say they're with the government, you're going to feel a little panicked. Keep these principles in mind. First, get their name and their phone number, and then say nothing else. Write those 2 things down, and then ask what agency they're with, and then call the agency. Back to, I said early in this that there were 3 times we've had people pretend to be government agents. Like we called the number on their card and you got a doo-doo-doo. The number has been disconnected. So don't call the number they gave you because think of George Costanza, who used to work for Vandelay Industries when he was looking for a job, and he would have Jerry pretend to be Vandelay Industries. People can lie about their phone number or give you their own cell phone and claim to be someone else and then wait for you to call back and they just answer the phone, U.S. Attorney's Office. So you've got to call the actual U.S. Attorney's Office to verify someone's identity on the phone. This sounds unduly paranoid. Trust me, it's not. If armed agents show up at the door, if they have a warrant, let them in. How do you know if it's a warrant? Well, if it says subpoena, grand jury subpoena, civil investigative demand, subpoena ducis tecum, any of those things aren't a search warrant. Only a search warrant will have search warrant on it. Anything else, you have time to figure out what they get. If they have a search warrant, you got to get out of the way. They're going to take stuff, right? You don't mess with people with a search warrant. You don't have to do it for them. You just have to get out of their way. Don't engage them in substantive conversation. Get their business card and get on the horn with legal immediately. You're inside legal or you're outside legal. Just don't wait. The agents will often take the beware of dog sign and replace it with a dog okay. They'll tell you it's not a big deal. If it wasn't a big deal, they wouldn't be there. I had a client in Central Illinois. An officer from Chicago had driven, 3 hours to their front door. Oh, this isn't a big deal. It's routine. Yeah, he was blowing his entire day to come on something that wasn't a big deal. That's just a lie. Now, agents will often use one of the most effective techniques in the world. Dead air. When people are quiet, they want to fill the silence and they will blurt things out. Are you here because of the X? Said one of our clients once. No, I'm not, said the agent. Why don't you tell me about that? Nothing good can come out of your trying to fill the silence. You need to be silent too. And in some ways, the more confident you are, the more you may want to talk. Sit tight. I am almost always a fan of cooperating in a big way with the government, but you want to do it patiently with legal counsel and with time on your side. This one wasn't a client of ours, but I read a case out of Michigan where the doctor said, my lawyer told me this was okay. That statement waived the attorney-client privilege, and the government was able to get all of the communications between the lawyer and the doctor simply because of the claim that the lawyer had told them that it was okay. Often these things are a big misunderstanding, but you're not going to convince someone of that in the first few minutes. All right, this is going to be a slow process, unfortunately. It's possible you violated a rule without knowing it. The agents may not have a perfect understanding of the rules. That isn't going to get solved today. This will be disheartening, but I would say, like, if I had to pick an average life expectancy of an investigation, I might pick 4 years. That's the bad news. The good news is I would say in 75% of the investigations where we've worked with clients, no money changes hands at the end of it. And over that 4 years, often a lot of it, nothing is happening. No legal fees are even being incurred. It's just a question of slow letting things grind. And it's helpful for everyone to understand the fact that the government is investigating something doesn't mean something bad happened, and it doesn't mean you're going to pay money. There's probably a 75% chance you won't. So what are your rights? Well, the agent can't make anyone attend an interview, with the exception, as we talked about, with licensing boards. They don't get documents unless they have a warrant or a subpoena. They can't get privileged information. So if it's information from a lawyer, they're not entitled to that. And they can't say, as they sometimes, well, they can say, I would prefer you don't tell anyone I was here. They can ask, they can't demand. So they can't prevent you from talking about the interaction, and a request that you not is just that. And make sure your staff understand this, because if a person with a gun says, please don't tell anyone I was here, most people will construe that as a demand, and they will not tell you that they were visited at home. So you have to, ahead of time, make sure your staff understand that they have the right to tell you if they're visited by a government agent. But you've got certain obligations. You cannot tell staff that they're forbidden from talking to the government. In fact, in your compliance documents, I usually recommend making it explicitly clear that a person is free to talk to the government, that they have that right. If they do talk, they don't have to. They don't have an obligation. They can always refuse to talk to a government official, but they have the right to, should they choose to. That goes over well with the government, and actually the opposite can be viewed as a form of obstruction of justice. If you do talk, you have to tell the truth, and this is the Fawn Hall portion of the discussion. You may remember she was Oliver North's secretary. She was shredding documents and carrying them out in her boots and her bra. Don't destroy and hide documents, because that is definitely obstruction. All right, we are basically done. A couple of cartoons and then some closing thoughts. I would have gotten away scot-free if I had just gotten rid of the evidence, but shoot, I'm a pack rat. Well, A, getting rid of the evidence is usually the thing that doesn't get you scot-free. This is one rare time I disagree with Gary Larson. And actually, keeping the evidence often does set you free, because in the Medicare world, often there's enough confusion that, in fact, keeping stuff is good. And take this handkerchief back to the lab, Stevens. I want some answers on which monster did this, Godzilla, Gargantua, who? In my experience, most agents are way better than this, and I am grateful for that. I always prefer working with a smart agent, because they'll get rid of the bad cases. A few closing observations. First, sometimes people will say to us, so if you think training like this is useful at all, we can do it, and we can do it either in person or from afar. Occasionally people will say to us, boy, I wish we could have hired you. And you can. Like, even if you're in another state, we have clients all over the country. We would be happy to do the training either via, like this, via webinar or in person. I've, Katie Ilton up doing that right now for a client. My colleagues do this all the time, so we'd be happy to do that. Don't forget the August 14th webinar about whether the manuals are binding or not. And then you'll have a link to this by Monday, and I've got a couple of questions here, which we will deal with right now. So first, with the patient with the fake insurance card, would the clinic just eat those charges and write them off, or can we bill the patient directly? Excellent question. There's no reason you shouldn't be able to bill the patient directly. That should be fine. The next question here, there's a question about what about high tech, and I don't know that I get the context on that one, so I'm going to punt on that one. Also, this is where it pays to have smarter people than you. When it comes to a lot of the high-tech stuff, I turn to Breyer and Dreesen, Katie Ilton, and Margie Amon, who know more about that than I. And since I'm mentioning Breyer, don't forget to check out the Twitter feed at Fred Health Law. I'm not a giant Twitter fan, but I follow Breyer because she makes me laugh. So I think that is everything we've got. As always, you should feel free to email any of us with questions. And the link that has this webinar should be up usually by Monday. If you want to suffer through it again, if you got interrupted in the middle. And if you're looking for the slides, they are in the email with the registration information. You can print off copies of the slides. Thanks, and happy Monday, and enjoy Bastille Day on Sunday.